Conrad Solar on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right. Please state your name for the record, sir.
Don Lee.
Okay, where are we on this case?
Thank you, Your Honor. This is a driver's license case, and I have discussed this with Mr. Lee. He will be accepting the offer extended to plead to MCL 257.326.
So, Your Honor, I'd move to add count 2 of MCL 257.326, allowing an ineligible person to drive. You accept that guilty plea to add count 2. I move to dismiss count 1.
Let's have Mr. Lee's point.
Raise your hand. Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Don Lee.
This court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding all that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind, but
Yes.
you cited an advice of rights form, correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's stated here today on the record to get you to plea? Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will? Because you believe that you are indeed guilty?
Now, this is where the hearing suddenly gets much more complicated. The judge isn't simply dealing with a misdemeanor anymore. He's trying to understand why Lee was placed in custody in the first place. The key issue is that the court appears to have acted based on the expectation that another case was about to be filed. And if that case never materialized, the judge has a serious problem to solve. Why is this man still sitting in jail?
Yes.
On the date of February 10th, 2024, Michigan Road near Moon Road in Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence?
Just very briefly, Your Honor. Mr. Lee is asking that the court consider sentencing him to time served. I do acknowledge he wasn't arraigned on this case until September 19th and only has 9 days credit, albeit he was not being held on this case. Outside of that, I just leave it in the court's discretion.
Anything you want to say, Mr. Lee?
And I just wanted to get this over with and keep him going.
You come back on that other thing tomorrow. Is it tomorrow?
He's up on the 8th for exam.
On the 8th.
For exam, Your Honor.
He's up there.
Just trying to recall. When I put you into custody, did we set an exam? Is that what
Yes.
we did?
Exam is on the 8th.
Before me?
No, it's before Judge Burke.
Okay. All right, I'll take a look at that because all right.
I think I have a file up, Your Honor. Did the court have a question I could help with?
Well, I put him into custody, but I know I told him I was going to take a look at that on the remand into custody on it because it came as a result of a police report regarding something else happening.
Yes, it was because there is a new case that is coming down the pipe, to which Ms. Blanche said that the warrant was going to be authorized that day, I believe. Mr. Lee advises, and I don't see anything to contradict that, he hasn't been arraigned on that new charge yet, however, but the 2 ones that he was in front of Your Honor for last week for PCC are set for exam, both cases in front of Judge Burke on October 8th. He's represented by Sam Bernstein in one and the public defenders in the other.
Okay, so my question becomes all right, that's right. That refreshes my memory. Where's that other case? Because the thing, I'm not asking.
Okay.
You don't know.
I know I ain't been arraigned on it.
No, I know, but I'm trying because
So you're,
I don't know, did I change his bond on, I did change his bond on that. He was supposed to then be arraigned on the other case, but that case was supposed to get, there was supposed to be a timing on that case to get down. So I remanded him. He was going to be held on these cases, on the ones that are set for exam. And then that other case was going to come down, expected that he might be in on that case. But if that case hasn't come down, I'm not going to be very happy right now.
Yes, to my understanding, Your Honor, he has not been arraigned on that new case, but the two cases that are already set for exam in front of Judge Burke, currently his bond is $15,000 on each of those cases.
Correct. I get that. What?
You raised it was a PI bond and you raised it up.
I put it up because of the representation of these other cases, but those other cases were supposed. What's the status of that other case?
Your Honor, Ashley Lottie, for the people on behalf of talking about these other matters. So if I'm reading this correctly, other cases was a resisting and obstructing case that was supposed to be coming down. Is that, Ms. Page, is that correct?
I don't think that was, it was involving a car accident and some other stuff.
I don't know the exact charges that were to be authorized, but I know the incident date was before the ones that are currently set for exam.
Right.
That being said,
I know.
Yeah.
Listen, where is that case? Because my problem here is that, and Mr. Lee is certainly not always the most cooperative person in the world, and he knows that. But he got remanded because his other case was coming down.
Correct.
And so I'm trying to, and I think there was a representation that it had been signed off or it was someplace, and the expectation was that case was going to get sworn out. While in custody, he'd be arraigned. And then there would be, based upon the facts of that case, a bond set that was likely or may have, I won't say.
Listen closely here, because this is a turning point. The judge is explaining his reasoning. He believed a new case was coming, that it could lead to an arraignment, and that a new bond decision might keep Lee detained. In other words, the custody decision was connected to something prosecutors represented was about to happen. But now the court needs proof that the expected case actually exists, and that distinction could completely change the situation.
I can't say for sure. May have kept him in custody, which is why I did what I did.
That was my understanding, Your Honor.
I just need a little bit more information.
Go, look.
So I want to understand, Mr. Lee was last before the court for PCCs. The court is saying on the 26th or the 18th.
I think it was a week ago, wasn't
I'm
it?
sorry.
I think it was.
The 20.
I think it was the 26th. He was before me.
I have some helping right now. So the new case, which does appear to be related to fleeing
That reaction from the judge, "Oh no, that will not happen," tells you the mood in the courtroom just changed. The court has now learned that the paperwork may have been sitting somewhere waiting to be entered, and the judge clearly does not want someone's freedom treated like an administrative backlog. This is a crucial legal principle in practice. When liberty is involved, procedure isn't just paperwork. Timing, authorization, and proper notice can matter enormously.
I have a police officer.
Oh, really?
Yes, that helps.
So, whoa. Is that what the log notes indicate?
Yes,
So, there are no charges?
correct. It says court does not find probable cause.
Okay.
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 Just hold. That's what it says?
Yes.
So there is no case?
Can I confirm the police report number for that? Yeah, I have it up. Washtenaw County Sheriff's Department report number 24-67821. I have 68821. I don't know if that's a typo, but.
And?
I'm checking with Melanie.
Yes, and while you're checking with them, have me bring them Mr. Lee's other two cases that are set for the 8th. Immediately. That's the last one I have, Chris. Now.
No.
Okay, let's. Okay, Mr. Lee, that's what we're gonna do. I'm gonna have them take you back,
Okay.
and what
All right.
court does. I haven't sent shit right.
You have not.
Okay, I took the plea, but he didn't send it. All right. Court calls case People versus Billy Pauling.
Ashley Lonnie for people.
Court recalls case People versus John Lee.
And there it is, the discovery that changes everything. The court's records indicate there was no charge to support what everyone had been expecting. That means the judge is now comparing what he was previously told with what the official record actually shows. This is why the courtroom record matters so much. Assumptions can move a case forward, but documentation is what ultimately tells a court what legally exists.
Sir, is the court calling felony matters or does it count?
I am calling the felony manager also.
Well, that's matters.
Assistant Public Defender Natalie Pate, with and on behalf of Mr. Lee, who stands to my right, please state your name again for the record, sir.
John Lee.
And I'm calling, so that we're clear, 24 FB 1322, as well as 224 F 1261.
It was 24F1322 and 24F21261.
The felony matters, yes, ma'am.
Thank you, Your Honor. Ashley Lonnie for the people in both of those matters.
Assistant Public Defender Natalie Pate, with and on behalf of Mr. Lee, who stands to my right.
I still have to sentence him on the driving well or the operating well. So we've taken a look at it. That complaint that I put Mr. in custody on was not, there was no probable cause found. And so that was not done. And I'm going to say this. They knew the reason. Mr. Lee understood what I was doing and putting me into custody. The prosecutor's office, I think, was given the representation made to this court, was under an obligation to contact this court immediately upon notification that those charges were not brought, knowing that that affected Mr. Lee's liberty. And I'm not happy that I wasn't contacted at all.
This is a moment where the judge makes the stakes crystal clear. Someone's liberty was affected by information that turned out not to produce an authorized case. The judge isn't saying every mistake is misconduct, but he is demanding accountability for what happened after the court relied on that information. And notice the bigger takeaway. The misdemeanor itself is almost an afterthought now. The real issue has become whether the system properly handled a person's freedom. Would you be satisfied with that explanation if you were the one sitting in custody?
Anything you want to say before I sentence him on his misdemeanor? Okay.
Nothing further, Your Honor. I would just reiterate his request to be sentenced to time served on that misdemeanor.
Fines and costs of $250. Those fines and costs are waived in their entirety. 90 days suspended on that case. With reference to his felony matters, those will continue to preliminary examination on October 8th before Judge Burke. Bond on those cases, both will be set at personal recovery.
Can you still please get all the previous conditions that were in
The conditions will remain. They never left.
Thank you.
It's just they took his liberty on something that didn't get authorized. You're going to be free to go, Mr. Lee.
I'm going home today.
You're going to be let out, sir.
Thank you.
Thank you very much, Your Honor.
Court's going to stand in recess.
All rise. Thank you, Your Honor. The 14th District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Jay said to preside.
Has the state prosecutor left?
I think so.
She needs to get back in here because I'm going back on the record on Mr. Lee. I don't know who else has that case. You may be seated, folks. Yes. At 1 o'clock?
Yeah, she has.
I want her here because I need a message gotten to that office right away.